Okay, well, it's 12:01 and I'm going to begin. Welcome, everyone. My name is Noura Yanaki, and I'm the president of the Arab American Bar Association of Illinois. AABAR is proud to present a CLE on violent hate speech and its impact on minorities as part of its pioneering biannual diversity and inclusion series. For those that are new to AABAR, we are a bar organization of close to 300 members, and have very active committees, including our esteemed CLE committee and judicial evaluations committee. We encourage you to visit our website at AABAR.org to see our prior CLEs, including presentations on diversity and inclusion in legal education and our presentation on voting rights. As a side note, the CLE is being recorded for educational purposes. Please keep yourself muted. And in order to receive the Illinois CLE credit, please email us in your name and ERDC number to info@aabar.org, or please drop it in the chat box. Without further delay, it is my honor to introduce the Illinois Commission on Discrimination and Hate Crimes Commissioner and our immediate past president, Marvet Sweis, who will be introducing our esteemed and distinguished panel of speakers. Welcome, everyone.
Thank you so much, Noura. It is my honor to introduce this distinguished panel, beginning with Justice Reyes, who was made Chief Judge of the First District of the Illinois Appellate Court. He is past president of the Illinois Judges Association and the Regional Hispanic National Bar Association. He co-chairs the Appellate Court's Diversity and Inclusion Committee. And notably, he is founding member and organizer of the Amazing Diversity Scholarship Foundation. We're proud to say he is also an active member of the Arab American Bar Association. Next, we have Mr. James Bennett, who is director of the Illinois Department of Human Rights, which administers the Illinois Human Rights Act, which prohibits discrimination with respect to employment, financial credit, and public accommodations on the basis of race, color, religion, sex, national origin, ancestry, military status, and age, sexual orientation, and physical and mental disability. Mr. Bennett is also chair of the Illinois Commission on Discrimination and Hate Crime, whose mission is to identify and uproot sources of discrimination and bias at the source while assisting with the development of resources, training, and information that allow for a swift and efficient response to hate-motivated crimes and incidents. We're so thankful to have him here with us today. And Professor Daniel McConkie Jr. joined the NIU Law faculty in 2015. He teaches courses on the First Amendment and criminal law and procedure. He appears on television and media as an analyst on current criminal and constitutional matters in the public eye. Professor McConkie holds an honors Bachelor of Arts degree in history from the University of Utah, where he graduated cum laude, and a Juris Doctor degree from Stanford Law School. Thank you for joining us. And now it is my honor to turn this over to our moderator this afternoon, Honorable William Haddad, co-founder of our Bar Association. Judge Haddad's legal career spans more than 40 years, with 10 years on the bench, and he currently serves as a mediator and arbitrator with ADR Systems. Judge?
Thank you very much, Marvet, and welcome everybody. I'm told that this is the largest number of viewers we've ever had on a CLE, over 130, and this is just splendid. On behalf of Professor Breen and I, we chair this committee. I want to thank everybody for tuning in. I just wanted to lay a little groundwork before we get started here about the nexus between what we call violent hate rhetoric and hate crimes, and maybe address this issue of, is there a way to curtail hate speech and still protect our First Amendment rights? So anyways, by way of background, the best background I can give you is our experiences at the Arab American Bar Association in recent history. And I guess I'll start with 9/11, when the horrible attack was perpetrated against the United States by foreign terrorists. There was a backlash against Arab Americans and Muslims, a gigantic backlash. And I hate to say that it had some sort of connection to rhetoric at the time. But the kind of violence we saw at the time involved, according to published reports, over 32 murders in 2001, 2002, 2003, involving Arab Americans and Muslims, or those who looked like us or spoke like us. There were countless arsons, assaults, batteries, Weapon choices were guns, bats, knives, pepper spray, cars, trucks driving into mosques and community centers. There was a plethora of hate crime. At the time, after 9/11, we heard rhetoric on the conventional media. There was no real platform at the time for social media, but through radio and printed media and TV, we heard people like, well, columnist Ann Coulter on the National Review, who after 9/11 made comments about Islam. Quote, "We should invade Muslim countries, kill their leaders, and convert them to Christianity." Rhetoric. Another was by Senator Saxby Chambliss from Georgia. He said at the time in November of 2001, "Just turn the sheriff loose and have him arrest every Muslim that crosses the state line." Or this quote, and it's a mischaracterization of Islam, but this was said: "Islam is a religion in which God requires you to send your son to die for him. Christianity is a faith where God sent his son to die for you." That's a quote from Attorney General John Ashcroft in November of 2001. And there's a plethora of other comments that were made at the time. This was counterbalanced by President Bush and the then 5 living presidents, Clinton, Carter, and so on, preaching calm and hoping to stop this hate violence that occurred after 9/11. Now let me bring you up to the primary elections in 2016 and 17 and 18, when the candidates vying for nomination made disparaging remarks, not just about Arab Americans, but Mexican Americans and Hispanics under the guise of immigration reform. But what they said about Arab Americans and Muslims, as reported by CNN, Fox, and MSNBC, were statements such as, quote, "barring immigration of persons to the United States based on religion, disqualifying American Muslims from holding high governmental offices, requiring American Muslims to register with the government, advocating the use of widespread surveillance of places of worship, and advocating the patrolling and securing of Muslim neighborhoods." These were the kind of statements that were noted by a well-known columnist for the New York Times, Robert Wright. Wright wrote, quote, "Perpetrators of hate crimes often take their cues from what they hear in the media. And the recent inclination of some politicians to use inflammatory rhetoric is contributing to a climate of hate and fear." What kind of climate of hate and fear? Well, in those years, 2016, 17, during those statements being made, we saw attacks upon Arab Americans, Muslims, Muslim Americans, and others who look like us in 15 states, from Arizona to Washington. Very often the targets were women and girls wearing hijabs. Places of attack were mosques, churches, residences, community centers. Weapons of choice were similar to 9/11. There are 2 notable instances that I would like to share with you out of the hundreds that I found throughout the country. One was the murder of 3 Arab American dental students in Chapel Hill, North Carolina during this time. Another was the murder of an Arab American restaurant owner in Tulsa, Oklahoma, whose killer said to him, "You are a filthy Arab, filthy Lebanese." So we heard rhetoric. I should also mention that there was an upswing in hate violence as reported by the Southern Poverty Law Center at the time and the Federal Bureau of Investigation, involving American Jews and other minorities. Now let me take you up to January 6th, our insurrection. And I've attached 2 papers regarding this. One is the Secret Service assessment for 2022, and the other is a voluminous report on social media and the connection between social media and the attack on January 6th by the Select Committee, Congressional Select Committee. And I'll just mention a few things about it and turn it over to our panelists. We heard rhetoric leading up to the January 6th insurrection on social media platforms. Rhetoric such as "Stop the Steal," "We're at war," "Lock and load," "This is it," "This is the hill to die on," "Kill all the feds," and so on. The committee issued a 100-page draft on this and its connection to the Capitol insurrection. And some of the findings were these: that social media platforms were a key driver in violent rhetoric by white supremacist, neo-fascist militia members. That we heard response of social media platforms, and they sort of claimed that there was nothing they could do, or there was little they could do. They claimed that although they were prepared for the threats involving the election in that November, they were not prepared for the post-election threats. Social media platforms said that they did not receive clear warnings of violence from law enforcement before January 6th. These are the findings of the select committee, by the way. They claimed that they lack enforcement against violent rhetoric, hate speech, and the big lie due to longstanding fear of scrutiny from elected officials and government regulators. They claimed that the fear of reprisal and accusations of censorship played a factor in their reluctancy to curtail the hate speech and hate rhetoric. They claimed that many media platforms use the cover of free speech to excuse the dangerous lack of content or moderation of it. These are all findings by the select committee regarding social media and their lack, they claimed, as they say, or allege, their lack of response to curtailing the violent rhetoric over the airwaves. Now, last month, the Secret Service issued a national threat assessment with a sample of various attacks in 2022. Some of these findings are of interest, and again, it's attached to the material for this CLE. One is that 1/5 of the hate-based attacks involve various members of racial, ethnic, religious, and political groups, as well as women and police officers. They also found that 1/4 of the attackers subscribe to a belief system involving conspiracies or hateful ideologies, including anti-government, anti-Semitic, and misogynistic views. And again, they cited that the online platforms were utilized by these violent groups to expound their hate rhetoric. So there's an issue of fear, threat, and violence involving violent hate rhetoric. And we're here today with this expert panel to hear what they have to say regarding the limits and protections involved. And we'll begin. I'm going to turn this over to my good friend, Mr. Justice Jesse Reyes. If you would, Justice Reyes, please proceed. And thank you.
Thank you, Judge Haddad. Just want to briefly say thank you to the American Arab Bar Association for the invitation to participate in this very interesting and hopefully everybody will find informative CLE. And it's always a pleasure to be with my friends at AABAR. So let me start off by the question is, what is hate speech? The United Nations, in an effort to define what is hate speech, stated as follows: in common language, hate speech refers to offensive discourse targeting a group or an individual based on inherent characteristics such as race, religion, or gender, and that may threaten social peace. In order to provide a unified framework for the United Nations to address the issue globally, the UN Strategy and Plan of Action on Hate Speech defines hate speech as, quote, any kind of communication in speech, writing, or behavior that attacks or uses pejorative or discriminatory language with reference to a person or a group on the basis of who they are. In other words, based on their religion, ethnicity, nationality, race, color, descent, gender, or any other identifying factor. The UN, however, to date has not found any universal definition of hate speech under the international human rights law. The concept is still under discussion, and especially in relation to freedom of opinion and expression, non-discrimination, and equality. Looking at the United States, per the American Library Association, there is no legal definition of hate speech under U.S. law, just as there's no legal definition of evil ideas, rudeness, unpatriotic speech, or any other kind of speech that people might condemn. In the United States, hate speech is protected by the First Amendment. Courts extend this protection on the grounds that the First Amendment requires the government to strictly protect robust debate on matters of public concern, even when such debate devolves into distasteful, offensive, or hateful speech that causes others to feel grief, anger, or fear. The Supreme Court decision in Snyder versus Phelps, 131 Supreme Court 1207, decided in 2011, provides an example of the court's legal reasoning on that. In another case that the Supreme Court addressed the issue of hate speech was really a case regarding trademark law. It was called Mattel, M-A-T-A-L versus Tam, 137 Supreme Court 1744, 2017. This was a group of young Asian American musicians who decided to call themselves the Slants. And some groups took that to be offensive, and there was a trademark battle that ensued as a result of the name of the group. And the court went on to state, with regards to hate speech, it's speech that demeans on the basis of race, ethnicity, gender, religion, age, disability, or any other similar group or ground is hateful. But the proudest boast of the Supreme Court's free speech jurisprudence is that it protects the freedom to express hated or hatred thoughts. And that was Justice Alito, who was the author of that decision, and there was concurrence by the other justices as well. One of the earliest reported cases involving hate speech in Illinois was Terminello versus City of Chicago, 337 U.S. 1, and it was a 1949 decision. A gentleman was at a park and was chastising some ethnic and minority groups shortly after World War II, as that they're being the cause as to why there was a number of unemployed veterans. There was a considerable amount of commotion. The gentleman was arrested, and the case went all the way up to the U.S. Supreme Court. And the court, in its decision, added, "The vitality of civil and political institutions in our society depends on free discussion." As Chief Justice Hughes wrote in DeJong versus Oregon, 299 U.S. 353, "It is only through free debate and free exchange of ideas that government remains responsive to the will of the people, and peaceful exchange is affected. The right to speak freely and to promote diversity of ideas and programs is therefore one of the chief distinctions that sets us apart from totalitarian regimes." Looking at the Black's Law Dictionary, the 11th edition that was issued in 2019, Black's Law Dictionary defines hate speech as speech whose sole purpose is to demean people on the basis of race, ethnicity, gender, religion, disability, or some other similar ground, especially when the communication is likely to provoke violence. So as we've seen, there's a lot of different definitions with regards to what hate speech is. And there really is no consistent legal definition as to what hate speech is in our country, at least. So unlike pornography, when Supreme Court Justice Potter Stewart was asked to describe his test for obscenity in 1964, he responded, "I know it when I see it." Our court still hasn't described, opined, or offered what is hate speech that is not protected under the First Amendment, and that would definitely assist the rest of us out here in the winterlands to determine, specifically what is protected and was not protected. However, our legislature in Illinois has not been impeded by that. And in on January 1st of 2018, new provisions in the Illinois hate crime statute took effect. These provisions concern both criminal and civil liability for hate crimes in Illinois. In addition, the law now provides civil authority to the Office of the Attorney General to pursue injunctive relief and civil penalties for hate crimes. The Illinois Hate Crimes Act, which is 720 ILCS 12-7.1, establishes criminal and civil liability for conduct that involves a predicate offense that is motivated by a protected characteristic, whether actual or perceived, of a person or a group of people. The pre-28 version of the law included the predicate offenses of assault, battery, aggravated assault, misdemeanor, theft, criminal trespass to residents, vehicle or real property, misdemeanor criminal damage to property, mob action, disorderly conduct, harassment by telephone, and harassment through electronic communications. The characteristics that can motivate a hate crime before 2018 and now are race, color, creed, religion, ancestry, gender, gender identity, sexual orientation, physical or mental disability, and natural or national origin. The first offenses under the statute are class 4 felonies, unless committed in certain circumstances, such as in religious buildings or in a school. In those cases, first offenses are class 3 felonies. In addition to a sentence, criminal penalties in the pre-2018 version included restitution to victims or a fine of up to $1,000, as well as completion of community service and educational programs. Civil relief in the pre-2018 version of the law included actual damages or punitive damages, but not both. Now, under the new act, changes to the criminal liability for hate crimes, the crime or the act now includes 4 new predicate offenses in addition to those already in the law. One is stalking, which could be found at 720 ILCS 5/12-7.3, and cyber stalking, which could be found at the same statutory provision at 12-7.5, transmission of obscene messages, which can be found at 720 ILCS 5/26.5-1, intimidation by means of inflicting physical harm on a person, subjecting any person to physical confinement or restraint, or committing a felony or a class A misdemeanor. And that could be found at 720 ILCS 5/12-6A1-3. In addition, the law expands the area where a first offense hate crime qualifies as a class 3 felony to include the exterior and the grounds of religious buildings. It provides that such buildings need not be used exclusively for worship or other religious purposes, but need merely be identified or associated with a particular religion. As for criminal penalties, the new law has lifted the previous $1,000 cap on fines to an amount within the court's discretion. It further requires offenders to attend in-person educational programs that focuses on the protected class targeted in the offense. Now, with regards to changes to the civil liability and procedure for hate crimes, as of 2018, there are 4 new aspects of civil liability for hate crimes in Illinois. 1, every act qualifying as a hate crime or criminal purposes now qualifies as a hate crime for civil purposes as well. Previously, only an individual suffering damage to his or her person or property could pursue a civil hate crimes such as harassment by telephone or through electronic communications. Now, every predicate offense listed in 720 ILCS 5/12-7.1A, which addresses criminal liability, can serve as a basis for a civil hate crimes claim. Secondly, while previous versions of the law did not address civil penalties, courts may now impose up to $25,000 in civil penalties for each violation of the hate crimes law. Courts may now award punitive damages and actual damages, and a judgment in favor of the person bringing a civil action under the law now must include attorney's fees and costs as well. Fourth, the Attorney General may bring civil action for commission of a hate crime, but only after consultation with the local state's attorney. The Attorney General is permitted to seek injunctive or other equitable relief in addition to civil penalties in practice before beginning any legal or investigative effort concerning the possible commission of a hate crime. The Office of the Attorney General will inquire with the relative state's attorney about whether that state's office has learned of or investigated the incident in question. If the relevant the relevant state's attorney has already investigated the incident in question and has determined not to pursue the matter, the Office of the Attorney General will seek information from the state's attorney to assist in its evaluation on the matter. Other governmental efforts to combat hate crimes in Illinois have occurred with regards to the Attorney General's office announcing on October 6, 2022, that they received $400,000 from the Department of Justice in a grant for hate crime training. The grant was awarded for a 48-month project to provide specialized hate crime training to law enforcement officers and prosecuting attorneys in Illinois. The hate crimes program will support the AG's efforts to increase the reporting of hate crimes and improve the criminal justice system's response to hate crime victims. According to the most recent FBI statistics in 2019, only 23 out of the 728 participating law enforcement agencies in Illinois reported any hate crime incidences to the Uniform Criminal Reporting or UCR program, which is one of the lowest in the nation. In
Okay.
Illinois, 24 cities with populations larger than 50,000 reported no hate crime incidences at all in 2019.
Thank you, Justice Reyes. We're
Yes,
going to have to move on at this time. So the other, we can get to Director Bennett. Thank you very much for the background. We asked you to present regarding some of these laws and statutes regarding hate crimes and so on.
my pleasure. Thank you.
I did want to interrupt just one moment. I'm so sorry. I did drop the agenda in the chat that includes the bios of all of our speakers today and the agenda for today's presentation, in addition to the written materials that Judge Haddad had referenced earlier today and the presentation that Mr. McConkie is going to be using later this afternoon. So please look at the chat box for those materials.
Thank you. I'm going to turn this over now to Director Jim Bennett. Director Bennett, proceed.
Thank you, and thank you, Justice Reyes. I have a couple points I just wanted to follow up on that. For the civil liability authority that the AG's office have, they just prosecuted their first case and won just a year and a half ago, maybe not even that long. So we've been really glad to have them sort of on the forefront of this. And then the comment about the numbers and how low they are, that's one of our larger issues that requires that a number is turned in, but not necessarily an accurate number. So it's a big challenge to get an accurate sense of what's happening out there. Thank you so much to AABAR for having me. I'm thrilled to have Commissioner Sweis on the call, who's a valuable member of our Hate Crimes and Discrimination Commission. And then of course, Judge Haddad, who is probably the biggest advocate to have Arab Americans at the table in every place of power, and that's how we move forward. Is this administration, the Pritzker administration, is committed to diversity and equity, but it's important that we're held accountable and make sure that everyone that we know and we see in society is represented at every level of power. That's how we move forward. So I'm very thankful to join you today. I will say I'm the non-lawyer on the call, so my comments will be probably a little less legal and a little bit faster, but I'm learning a lot, so I'm very happy to be here. The Illinois Department of Human Rights, we're actually created by the Human Rights Act, which is about 44 years old, came out of the Civil Rights Act, the US Civil Rights Act, and it created two agencies. So it created the Illinois Department of Human Rights. It's a cabinet level agency. I sit in the Governor Pritzker's cabinet, and at the simplest way to look at us, we are investigators. We conduct neutral investigations looking for substantial evidence. We're equivalent or better, in my opinion, to the EEOC and HUD. And then our cases go either to circuit court if we find substantial evidence, or the Human Rights Commission. And at the heart, the Human Rights Commission are adjudicate the decision and provide the remedy. And so we work hard to take on any charge where people feel that they've been discriminated. And the reason I bring this up, although it's the human rights takes civil charges around discrimination and hate crimes as criminal, it's a continuum, you know. So I think we all sort of have experienced hate in one form or another, and whether it's it's some kind of microaggression that we begin to see a pattern of, all the way leading up to violent acts of hate. We encourage people when they've experienced anything to at least file a complaint with our office, because if it is beyond our scope, we can make those referrals to where that case would go. But oftentimes, what we see are is the beginning of hate, in our work. What's covered under unlawful discrimination, whether it's things like employment or housing, financial credit. It also covers disparate treatment, disparate impact. Harassment's been greatly expanded, and the definitions of harassment in the last few years. And in many ways, what we see is there's a very thin line between bullying and harassment. And so there's times where we can take on those cases. But again, our work is directly associated to a protected class. So in some places, like in schools, for example, where if you have the smart kid being picked on or someone for being overweight, those are sort of the gaps that happen with some of the harassment laws where they may not be covered. And then the most common is retaliation. So it's when someone has filed a case and then they find that they're retaliated against for filing the case, and then that's illegal as well. The Commission on Discrimination and Hate Crimes, the statute is about 13, 14 years old, but it sat dormant for 11 years. And it wasn't until this administration that we brought it back. It's 21 members. It has a few agencies, obviously where I'm from, the Department of Human Rights, the head of the Illinois State Police, Brendan Kelly, Amy Meek, the head of the Civil Rights Division from the Attorney General's office. And then the remainder of the commission is people that represent the protected classes, and as diverse as we can be for 21 people, and always an effort to try to expand, to make sure that everyone's at the table, and if they're not, to make sure that the people that we have are reaching out in a practical way. The commission began in April of 21. We spent a year really out there trying to figure out the state of hate in Illinois and then across the country. We were shocked, as my fellow commissioners could share with you, that we kept being told how far ahead we were, and none of us felt that way. But we're one of two, maybe three now commissions in the statewide commissions in the country, and so we've sort of been alarmed, to be quite honest, of the lack of good data out there. Every time you hear a story about hate crimes, the question is always, how bad is it? And our assumption is it's significantly, at least 4 to 5 times higher than we're seeing in the numbers that get reported. And we could go into that. There's a variety of reasons why those numbers are underreported. In March of last year, we made recommendations to the Illinois Assembly and to the governor's office on how to move forward, what we thought needed to happen to the great credit of the Assembly, and I would say immediately retired Leader Harris, we established a $5 million account in the lame duck session that that is a multi-year account to get these recommendations moving in at quick speed. We hired our first executive director of the commission, who's actually on our call today, Ilda Baena, and we're moving very quickly. So the initiatives that we have before us, first is to conduct a needs assessment across the state and really work with people in all the protected classes to understand how hate impacts each of those communities. We're working on a project to try to inoculate people from being radicalized, and especially Judge Haddad spoke to the sort of scourge of social media and the ability to share things that sometimes people don't even realize what they're sharing until they're too far down a path. And so we're working on how to inoculate individuals by helping them understand where the source of their information is coming from. We'll be establishing a helpline for people that have had hate crimes or experienced hate crimes that we have every intention of having up and running before the end of this calendar year. And it's really focused in two places. So one is the legal issues of getting people to file. Right now, it has to go through law enforcement. And there's challenges in both ways. There's people for a variety of reasons that don't feel safe or uncomfortable or ashamed to report it. And then there's issues with law enforcement of getting that case to be pursued and to be looked at as a hate crime, and to ask the question of why that brick was thrown at somebody, as opposed to just asking where it happened and how it happened, but to really explore it. We also want to be looking at hate crime incidents. So we've seen where only hate crimes are being measured, but if there's anti-immigrant slurs painted on a building, if there's a swastika painted on a building, if people are being yelled at, we want to know those incidents and start recording them as well, because that's going to identify hotspots for us as to where we need to focus and be. And then on top of the legal issues of pursuing a hate crime, it's a horrible trauma, and it's not just a trauma for the person that experienced it, but it's a trauma for that community. If someone is gay bashed near me, then I'm no longer feeling safe in my community and where I can go and where I can be. And so how we can start addressing the trauma related issues. And then our step that we intend to get to in the next calendar year, ideally close to the end of this one, is begin to issue grants to resources out in the communities across the state of Illinois that can serve as a network for us both to refer to and can refer into us. Because if you experience something horrible happening to you, you're going to go to someone that understands you. If I'm Vietnamese, I'm going to go to probably the Asian Americans Advancing Justice, and we need to make sure that they're armed with all the information that both the department and the commission and law enforcement can provide to them. So that we expect to be able to move to within a year. And I'll just close with saying that it is a terrifying time, without question. We have seen hate increase, and really, and in great credit to the past presidential administration, given a voice, given making it acceptable to hate, and almost a badge of honor to say these absolutely horrendous things. What we need to do is recognize that we are not defenseless in addressing it, and that's where our focus will be now and in the years ahead. Thank you.
Thank you, Director Bennett, and for that information on the execution and implementation and the spirit behind the law that we're discussing today, or some of which we're talking about. And we're also very excited that you selected our very own Marvet Sweis to sit on your commission. And we hope that you will continue your good work for inclusion and diversity. Now it's my pleasure to turn this over to Professor McConkie from NIU Law, who works with our favorite Dean Cassandra Hill. So, Professor, why don't you proceed?
Thank you very much, Judge. This is really an honor for me to be able to present to all of you today on such an important and really quite a difficult topic. I will do my best. I've only got about 10 minutes to just kind of give you a taste for the law. I've posted my slides here in the chat. I posted some other materials that you can look at, but I'd like to kind of keep it on a high level and talk about one or two key cases, and also the why of First Amendment law and what other options we might have available. I should say, when I talk about the law, I think my time is best spent explaining what the law is, and not make the arguments for what I think it ought to be. But I do acknowledge that probably half the people on the line here have a different opinion about this topic from the other half of the people on the line. Public opinion polls show that a lot of Americans feel that the First Amendment should not be applicable to hate speech. And there are a lot of good reasons for people to have that opinion. I guess another point I'd make, and I'd piggyback off of Commissioner Bennett's comment about not being a lawyer. Never be embarrassed not to be a lawyer. Lawyers have some interesting thoughts and perspectives on social problems, but there's no social problem that the law solves. It's really one way to look at things. And I tell this to my First Amendment students: there's a legal First Amendment and there's a social First Amendment. And the social First Amendment is just important. When I say social First Amendment, I mean the way we treat each other in civil society, the way we attempt to reason with each other and listen to each other and put up with each other and learn from each other. And that is a big part of the solution, if you could say there is a solution, to hate speech. I feel the need to preface my remarks with this because if you're concerned about hate speech, as I certainly am, a lot of this might come as bad news because hate speech is not a protected category under the First. It's not an unprotected category under the First Amendment. That's why the Supreme Court hasn't made an attempt to define it. There are cases out there where state legislatures try to define it, and the Supreme Court takes the case and usually will overturn that statute or limit it because it turns out to be pretty darn hard to write a statute that criminalizes hate speech. Pretty hard to define hate speech in a way that everybody agrees with and that doesn't also sweep in a lot of speech that really ought to be protected. So with that, let me just share my slides here. And again, I'm gonna breeze over some of them because we have just a few minutes, and you can peruse them later if you're interested. Okay, can people see that? Great. Good. The basic constitutional point that I'm going to make here is that hate speech is generally protected by the First Amendment, period. However, some First Amendment categories allow some hate speech to be regulated. This first point is key. I'll explain why the First Amendment protects hate speech. The First Amendment supports a general theory of government, politics, and society that strongly supports the free exchange of ideas. And that means virtually all ideas, even ideas that everyone in this room find to be repugnant. All those who participate in this free exchange are free to listen, to accept or reject. And in theory, the way that we change people's ideas is by persuasion and not by legal compulsion. Now, there are other ways to do this, right? You all probably know in places like Canada or Europe, hate speech is regulated. That isn't the route we've taken in American law. I've got a case here cited by Oliver Wendell Holmes, who you might call the father of modern First Amendment case law, constitutional law. And he said, if there is any principle of the Constitution that more imperatively calls for attachment than any other, it is the principle of free thought, not free thought for those who agree with us, but freedom for the thought we hate. I could go through a bunch of cases about the Supreme Court overturning convictions of people who had done something really offensive to some and been criminally convicted. And the Supreme Court stood up and said, our First Amendment simply doesn't allow people to be punished for their speech. Cohen versus California, that famous jacket. We've already talked today about Madhal B. Tam, about the band that called themselves the Slants. The Supreme Court said in that case, speech may not be banned on the ground that it expresses ideas that offend. Let me hit just really one key hate speech case. The others are in the slides if you're interested in looking at it. Beauharnais, an early authority from the 1950s that implied that punishing hate speech was okay, but the Supreme Court abandoned that precedent. But let me talk about Chaplinsky and RAV versus St. Paul. And those, I think, may help you to understand the legal landscape for whether and how hate speech can be regulated. Chaplinsky is an older case of a man who engaged in speech that many found offensive and was convicted. And the Supreme Court upheld the conviction in this early case and defined a category called fighting words. Fighting words can be regulated, but it is a very small, narrow category. It is those words having a direct tendency to cause acts of violence by the persons to whom individually the remark is addressed. And that is an objective test, whether men of common intelligence would be words likely to cause an average addressee to fight. All right, that's the precedent you need to understand to get to this case, which I think is probably the one most important case on hate speech that hasn't already been discussed, and that's RAV versus City of St. Paul. That's where a local city passed a bias-motivated crime ordinance and successfully prosecuted a minor, a young man, who burned a crudely made cross inside the fenced yard of a Black family. The important thing to know about the statute is it criminalizes conduct, placing on private property a symbol, object, etc. And then here's the mens rea, which one knows or has reasonable grounds to know arouses anger, alarm, or resentment in others on the basis of race, color, creed, religion, or gender, right? I think we can all understand why the city council wanted to criminalize this behavior. The Minnesota Supreme Court narrowed the law as applying only to fighting words, which the Supreme Court had previously stated could be regulated without regard to the First Amendment. And notice here that the crime gets at conduct. In this case, for example, the young man had actually burned a cross on private property. And so this is hate speech plus. Nonetheless, the Supreme Court overturned the conviction and held that content-based and viewpoint-based restrictions on speech are generally invalid, even if it is racist speech. The court further held that the effects of the speech could not be considered as a reason to regulate the speech. In other words, I think we'll all agree, racism, hate speech do have terrible social effects. But in RAV versus St. Paul, the Supreme Court said the effects of speech on other people are generally not enough to justify regulating it. Actually, that'll hit the key point for that. I'll make one kind of brief point, and that is, even though hate speech as such may not be regulated, there are many categories under the First Amendment of speech that can be regulated, and often these categories include hate speech. I spoke to you about fighting words. Another would be incitement to imminent lawless action. Another would be true threats, like criminal threats that we're familiar with here under Illinois law and the law of the other states. And finally, several other conduct-related crimes that have some kind of speech or thought aspect to them. If it's drafted correctly, for example, hate crimes are permissible under the First Amendment. That's the conclusion of my time, but I hope that explains why the law is what it is, and also gives us some hint as to what we can do about hate speech. We can speak against hate speech. We can speak out against it. I don't say that that will snuff it out, but as citizens, we can speak up and unite and do something about it through debate and reason and persuasion. Thank you.
Thank you, Professor. It's interesting that in the opening statement, we talked about rhetoric back in 9/11 and then in the presidential primaries in 2016, which might or may not have resulted in fueling violence, but the January 6th insurrection and the incitement to a riot is another issue of speech that may or may not come under the purview of your latter statement. So we'll see. I would like to, at this time, turn this over to my good friend and co-chair, Professor Breen, John Breen from Loyola University Law School. John, take it away.
Thanks, Judge. First of all, we'd welcome some questions in the chat in the time we have remaining. There aren't any currently, so let me pose a couple of questions. And again, thank all three of the presenters.
The chat is disabled. That's why there's no questions. I'm sorry.
Okay. Didn't know that's how
I will change that right now. I will change that right now.
Yeah, sorry for interrupting. I thought the meeting was going to end in like 10 seconds if I didn't say something.
No, I appreciate that. I believe you have an opportunity to send a message to only the hosts. Is that also disabled?
It is also
That was an option early on in the meeting, but now it's not.
I will fix that right now.
Okay,
in terms of taking advantage of the time we do have left, let me pose this one question to Jim Bennett, because you had mentioned before that there's this, I think, like chronic underreporting. And how do we know that? How do you know that you don't know, I guess would be the question.
Yeah, it's a good question. Some of it is just things, for example, in Champaign-Urbana, we saw that U of I had turned in a number and then the counties had turned in a lower number. We have multiple counties in Illinois that turned in 0, even though we had incidents that had been reported or investigated. And it's the system of collecting the data is very scattered. So usually it needs to come through law enforcement and the state police collect it, but there's no resources put behind that. So it's just you turn the numbers in, but there's no ability to follow up without. So one of our goals that is to begin linking and starting better communication and trying to track that. Oregon, the state of Oregon has made extraordinary progress in developing a much more accurate system of gathering that data.
But is that communication with parties other than law enforcement?
That's the official place where it would have to be, but so it just depends. So in the way in Oregon is set it up is through the AG's office and a similar program that we just received funding to develop. They'll be working both with law enforcement, but also tracking incidents and actual activities, and then going back and doing comparisons from what was turned in into the helpline that was set up for trauma instances, and then go back and compare that with law enforcement, and then work to figure that out. It looks like Justice Reyes is jumping in this one.
Yeah, I just wanted to, based on the information that I know with regards to the FBI's uniform crime reporting, they sent out these requests to law enforcement throughout the various states in the country, and it's their responsibility to report back to them. And it's not only just incidences, but they want to also know about offenses, the victims, offenders, and the location of the crimes. And that's why I think they know, why our reporting in Illinois is so low, because they've sent them out to the various law enforcement agencies throughout the state, and only a handful of agencies in Illinois have reported.
And that ties to the issue, Justice, that you brought up on training, because right now we only have Illinois State Police and the city of Chicago that does hate crimes training. Other than that, it's very scattered. So for the AG's office to now have this 500 grand grant to develop training and push it down through all of law enforcement, and ideally we'd like to see it go to prosecutors and judges as well, although not mandated, to help expand the understanding of what a hate crime is. Because I think sometimes law enforcement will do everything right and they'll prosecute a case, but they didn't realize it was a hate crime and it didn't get categorized correctly.
John?
Here's another question, this for Professor McConkie, following up on what Judge Haddad said at the end, talking about January 6th and incitement. You didn't cover the standard for incitement, which is a very high one, and I think but that's relevant here to our discussion of the possibility of regulating hate speech.
Yeah, thank you for that. Here, I'll share my screen and show you the, here you go, is the standard on incitement. Coming from the Brandenburg case. The government may not abridge advocacy of force or illegal action unless it is intended to inciting or producing imminent lawful action and is likely to incite or produce such action. And so the January 6th events are a good example of speech that may well qualify for that, but it's really rare that there's a successful incitement prosecution. The Supreme Court has tended to find that those elements are not satisfied when it reviews criminal prosecutions.
Yeah, it's in I think Judge Haddad put it in the chat, Article 20 from the International Covenant of Civil and Political Rights adopted by the UN in 1966 prohibits any propaganda for war as well as advocacy or national or religious hatred constitutes incitement to discrimination, hostility, or violence by law. Would that fit within Brandenburg? I mean, it uses the word incitement, but it goes beyond that, doesn't it?
That's right. The old cases, right, during World War I, there were a lot of criminal prosecutions of people that were inciting in sort of the broad sense, and the court saying, yeah, this is dangerous speech. And then Brandenburg, the Supreme Court really doubled down on an imminence requirement. And so it's not enough that it's hate speech. The question is it imminently going to cause a crime? Like right now, is it going to cause a breach of the peace? Right now, is it going to cause, a violent revolt? And the answer typically is no, under that definition.
And can I ask a quick question?
Sure.
Professor, I know you said you looked throughout various states that have implemented laws to try to prevent hate speech. And I know this is a kind of subjective format, but hate speech laws could also mirror like the obscenity laws and, for example, incite violence. But has anybody tried to implement in their statutes that it would incite hatred? Because that's basically what the hate speech is supposed to do. And as a qualifier with regards to a test, has anybody in their state statutes to try to implement incitement as to hatred?
My opinion is that such a statute would be swiftly overturned by the Supreme Court because hatred is not a crime. So inciting hatred is likewise not a crime.
Okay.
Yeah.
There's a question here, and I don't know if we have time here. There's a question here in the chat. I'm a Palestinian American and curious why criticism of Israel while advocating for Palestinian human rights is punished. In some states, employers make employees sign a document for this. How is this allowed? I wasn't aware that was taken.
Well, that if I could just interject, that's something that people are proposing as anti-Semitism, and that it should be banned. Criticism of Israel. It's a whole different subject, and I understand the question. And I don't know if that definition of anti-Semitism, including criticism of Israel, has ever been adopted anywhere in the United States. But may I, John, I'm sorry to interrupt that, but
No, go ahead.
Give us our closing remarks because we're limited to an hour. And I want to thank everybody. You've done a wonderful job today.
You're welcome.
thanks.
Also, whoever asked the question about incitement, like I've actually done my own personal research that can answer that question on what kind of statutes have been tried in the United States. I actually did a research project last semester in law school, and part of it was researching why the United States doesn't have hate speech laws and the rest of the world does. And one of the mind-blowing revelations was that it's not that the United States doesn't have hate speech laws necessarily, it's that we used to. During the early 1900s, there was actually quite a few of them throughout the states. As we built on Anglo, like English jurisprudence, they had this concept of group libel, and that at least, I believe one law review article I cited said that by 1952, at least 7 states and several cities had group libel laws on the books.
Hey, Sean, that's a great point, and I've got it in my slides. Why don't we let them conclude here, and
Yeah,
you and I
sorry.
can chat about it.
Sorry, I had the answer to the question. I'm sorry. I can get sorry.
For another time, leave us hanging. Professor, well, anyways, on behalf of Professor Breen and myself as co-chairs of this committee, I want to thank everybody for participating today. This was wonderful. Thank the committee and President Yannicki and Marvet, Sweis, and everyone else that participated today. With that, we can close. Is that right?
Thanks
Okay.
very much.
Thank
Thank you,
all.
everyone.
Bye-bye now.